morning. As you know, each party has 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, please let me know, as I am keeping time.
Yes, sure.
We've read the briefs and we're ready when you are.
Thank you, Your Honors. May it please the court, and I do apologize, my voice is going to be difficult. I have had a cold, I have contracted laryngitis, which is one of the worst things that can happen to a lawyer, but the best thing for a lawyer's spouse. So I would like to reserve 3 minutes for rebuttal in this case.
3 minutes, you said?
Having read the brief, Your Honor, I'm not going to do you the discourtesies of reviewing that with you, but I would rather just make an argument in this case that is more pertinent to the issues that we face. This case started in the lower court as a domestic relations court case. It was unusual only in the fact that there was a very substantial amount of money, there were businesses involved, and there was a great deal of animosity between the parties, which is not unusual in a domestic case. The question is whether that animosity rose to the level that caused the court to issue ex parte orders in this case. Going back to the beginning, Mrs. Smith brought an action against her husband for divorce and also asked the court to issue certain restraining orders. Those restraining orders were issued, first of all, as the court's standard order, and then there was additional restraining orders that had to do with the functions of the business. Those, in essence, were responded to by Mr. Smith, and hearings were set before magistrate, in this case, Magistrate Guy. And those orders had to do with financial dealings between the parties as well as the parenting times. There was never any evidence presented at any of those hearings. No one was ever under oath. Only the statements of counsel were presented. As our court cases establish, statements of counsel are not evidence. And that's kind of a key in this case as well. But what happened was there was two basic hearings that were presented. The second hearing was on August 27th, and that was before Magistrate Guy. It had to do with as many as 7 motions that were then pending, including motions by Mr. Smith. A resolution was had at that point in time with respect to the issue of an oversight of the business, in this case known as NTX, and Coastal Tool Supply. It was questioned whether Mr. Smith was appropriately operating the business, so we agreed, have an overseer. Have somebody come in and review the actions. There was no talk of a receiver in that agreement. It was as an overseer, and that was confirmed by the issuance of Magistrate Guy and her magistrate's decision issued in September that said an overseer is appointed, and that person is Mr. Haley.
What else is in the record with respect to evidence of this agreement of an overseer versus I asked for a receiver, the court granted an overseer?
It was by agreement, and the agreement is contained in the transcript filed with the court of the August 27th hearing. The agreement was by counsel. You'll find a portion in there where Mr. Lowry, who was counsel for Ms. Smith, stepped out of the room, contacted Mr. Haley, wasn't able to do so, but we agreed that he could be appointed. Mr. Haley declined, although he then became counsel to the receiver, which we find to be an unusual turn of events. And Mr. Collins then was selected as an overseer, and that was a subsequent and then amended decision issued by Magistrate Guy.
And is the business a party to the divorce proceeding at this point?
One portion of the business was a party at that time, that was NTX. There was a separate business known as Coastal Tool Supply, LLC, that was not then a party, but subsequently became a party to the divorce case. So we all agreed an overseer is appropriate. The overseer never took any
What's in
action.
the record about that?
The agreement is,
The agreement and the duties of the overseer.
the duties were established by Magistrate Guy in her opinion that was issued,
Okay.
and indicated that,
Thank you.
okay, and that never happened. 20 days later, they filed a motion to appoint a receiver. By the way, they had already filed a motion to appoint a receiver prior to the August 27th. The resolution by agreement was on August 27th, journalized by the court in September. Therefore, those motions were deemed resolved. Law of the case, that's the way it was. They then filed a new motion containing no new evidence, containing no affidavits, on October 8th. And the court issued an ex parte decision granting the receivership. We filed a response requesting a hearing on October 9th, the same day that the court granted the ex parte motion. The response of the court was to reissue the decision, not to set a hearing. And that's why you have two appeals, October 9th and October 17th. Those are the exact same orders issued by the court. I say they are in response to my request for a hearing. You're not getting one. Reissue the decision. They then file a motion to stay. Decision reissued again on October 27th. That order was issued 3 times, despite our request to the court for variances of the processes by which a receiver can be appointed. This receiver can only have been appointed under 2735 subsection 7, other reasons. Because we're not talking about 2 commercial entities or a commercial entity and a judgment debtor or somebody else that has an interest in it. This can only be granted in equity. And the courts are clear that you must have a hearing, you must have the presentation of evidence, and it must be by a clear and convincing standard. There was none. There was none. And it was subsequent to an agreement that resolved the first 2 motions for a receiver. And your honors, it's in a divorce case.
Is there anything in the court's order appointing the overseer that the court can see hasn't happened, that was ordered to have happened? I mean, was the overseer to report within so many days?
It did not indicate any requirement of report. The overseer never took any actions.
I
But
understand that in reality you didn't. I just wanted to know if there's anything in the record that says this should have happened, that the court can see it didn't happen.
No, your honor. And the period of time to object to the magistrate's decision had passed by the time the second motion for the receiver was filed. Because it was filed 20 days after the magistrate's decision. The magistrate therefore was beyond that 14-day objection period. So it became part of the case without objection that an overseer was to be appointed. I don't know what new evidence you can have in that 9-day period of time that would cause the court to have a different consideration, different issues, and we don't know because we never got a hearing, despite request. And that's the key. All of the cases that are discussed, all of the cases focus on what evidence was presented to the court. In this case, there's no evidence except they refer to an affidavit by a self-serving participant to the case itself, and a strange spouse who says, I think he's going to take one. I can't imagine a case, in my 35 years of practice, that's never come up. Yes, it has. Spouses say that about each other.
It was a little difficult to follow the timing of events, but it sounded as if these orders were issued after a number of hearings or court proceedings were set, and husband did not appear, and in some cases did not appear through counsel.
I don't believe that to be true. It didn't appear through counsel because I was counsel, and we did appear. We did ask for a continuance of the May hearing because we had just been retained at that point.
Maybe it was before you were involved in the case.
And then orders were issued before he was even served with copies of the divorce complaint. They were issued ex parte as well. Not just the court standard order, but a subsequent restraining order, which we then asked to overturn. And we filed our own motion for restraining order because we believe that Cheryl Smith was trying to take money out of one of the accounts, which resulted in a federal action brought by Merrill Lynch to receive direction because they were receiving what they felt was conflicting directions from co-owners of the business. But anyway, August 27th, the record will show that I contacted Mr. Smith while in the courtroom, and he indicated he thought that the hearing was on August 28th. It was an error that he made, and because he lives an hour and a half away, he lives in Vermillion, he would not be able to make it for that. However, I did receive his authority, as is reflected on the record, to come to an agreement on the overseer. What we didn't have was an agreement yet on the temporary orders, although the record should reflect that Mr. Smith and Mrs. Smith were taking the exact same amount of money out of the business at that point in time. They're taking $10,000 a month. And that was in some of the pleadings that you will see. So, yes, he didn't show. Yes, it was a mistake that he made by not showing. I asked for a continuance at that hearing after I contacted him, and then we proceeded to go through some of the items that were there, no evidence being presented, and then that's when we came to an agreement on an overseer. I said I won't agree to a receiver. I would agree to some oversight by an independent third party. Mr. Lowry agreed that that was acceptable at that point in time, and that's why Magistrate Guy issued her order in September.
And will we find, was the hearing conducted on the record?
It was, and the record is before Your Honor.
Okay, and will that record reflect what you just recently said, that you said on behalf of your client that you will not agree to a receiver, but you would to an overseer?
Yes, sure.
Okay, thank you.
I don't know how much time I have left. I was trying to reserve 3 minutes.
At 4 minutes exactly.
Okay. But, Your Honor, we believe that this case, and it's a final appealable order on anything having to do with the appointment of receiver because it's an extreme remedy. Because of the extremity of the remedy, there are certain safeguards which were not granted to Mr. Smith in this case. He didn't have the chance to respond. He didn't have a chance to present evidence. He didn't have a chance to cross-examine any evidence. He asked the court for those. It was denied by implication, by the reissuance of the order, and it is those rights that he had that have been taken away. We don't even know if a receiver should be appointed because there was no evidence presented. It was a final appealable order, so anything the court did subsequent thereto with respect to the receivership should be declared void. I understand that the divorce case can proceed unrelated to the appointment of the receiver, but it is very clear from the case law, and we recited to you, that we're requesting that this court issue an order that not only voids the initial finding, but any subsequent findings by the court with respect to a receivership. I believe I probably used my time. I reserve 3 minutes. Thank you, Your Honor.
Yes.
Good morning, Your Honors. Ken Gibson on behalf of the appellee Cheryl Smith. Mr. Haley is here on behalf of the receiver. We've agreed that I will make the presentation, but he will be available to answer any questions that the court may have with regard to the issues in the case. I'd like to start by saying that in my appellee's brief, I noted on page 12 that although there was an appeal from Coastal Tool Supply LLC and NTX Inc., those parties did not, and that was a separate appeal, those parties did not file a brief in this case. And I had indicated in my brief that I felt that their appeal should be dismissed. Now, why is that important? It goes to the extent of the relief that the appellee or appellant is entitled to if, in fact, the appellant were successful on appeal, which we don't believe they will be. If the corporations are not a party to the case, and they're the ones with the standing to contest the order as it relates to the corporation, because an officer, case law is fairly clear that an officer doesn't have separate standing to appeal a receivership order. But in any event, if they are the parties that could contest that, then the receivership as to those parties should not be affected by this appeal. Now, Mr. Smith does have a separate standing and to challenge the receivership as it relates to the properties of which he's a joint owner. There's no question about that. He has standing to bring these arguments, just not to request the relief as it relates to the corporations, in my opinion. There's no statutory provision for an overseer. There was discussion in the transcript. And Mr. DeMarco is correct that he agreed that on behalf of Mr. Smith, that an overseer could be appointed both as to the businesses and as to the rental properties that he was co-owner of. The word overseer, in my judgment, based on reviewing the orders, I wasn't at the hearing, really referred to a receiver with limited powers. Because they talked about, he was not going to run the companies, but he was going to have certain financial access to the business records, and he was going to be able to review certain transactions. And as to the real estate, he was actually going to collect the rents and then distribute them equally to the parties. The orders that are being appealed are merely an expansion of that original order for the appointment of an overseer / receiver. I question whether or not that the expansion of the powers of a receiver is a final appealable order, as opposed to the original order, which was consented to by the parties. Typically, the administration of an receivership is, in fact, produces lots of orders, and none of those are final appealable orders, only the original order setting forth the receivership. I'd like to address the issue of notice and how this came about. The appellant contends in his reply brief, and he's asserted here, that the orders of October 8th, which is the start of the actual receivership. There was an order appointing the overseer, that terminology, but with some receivership powers, on September 3rd by the magistrate, and then another order on September 19th, I believe. And those orders were not appealed from. The first order granting expansive powers was on October 8th. And so we believe that the order for appointing a receiver in a domestic relations case is an extension of the court's authority to issue temporary restraining orders under Rule 75I. The goal in the domestic relations case, and these were denominated temporary orders in the original orders by Magistrate Guy. The goal of the domestic relations judge is to preserve the assets until such time as the final hearing, and they can decide how they're divided up. There was a lot of concern that these assets were being dissipated in a way that, there was a federal lawsuit over, freezing the accounts, the primary accounts, all kinds of stuff going on, of which the court was aware.
Well, your opposing counsel has indicated that, yes, there was concern. The issue is, was there any evidence?
Okay,
Where there was
I'd like to address that directly. Because under Rule 75I, if these are an extension of the court's power to issue temporary restraining orders, the temporary restraining order under Rule 75I of the Ohio Rules of Civil Procedure merely requires an affidavit, a single affidavit. And that was in fact provided by Cheryl Smith. He calls it self-serving. That doesn't matter. It's an affidavit. So the court had the authority to issue temporary orders as it relates to preserving the assets. Rule 75I specifically says that those orders can be issued without notice. All right? Now, he's also said in his reply brief that the court violated its own local rules. Well, I beg to differ. The local rule specifically says that hearings on temporary orders are going to be done by statements of counsel. And if a party has an objection to proceeding on statements of counsel, they must file a request for an evidentiary hearing. That's Local Rule 9. And if he had filed a request for an evidentiary hearing, either on his own motions or on our motions, he would have gotten one. He goes to a hearing that's on statements of counsel, which is the normal rule in the Domestic Relations Court for temporary orders. And he makes no objection to the fact that we're doing this on statements of counsel. I've reviewed that transcript again yesterday, and nothing in there suggests that there's any objection to proceeding on statements of counsel. And of course, he couldn't proceed on an evidentiary hearing even if he wanted to, because the client didn't show up. But nonetheless, I mean, that may be why. But in any event, there's no request for a hearing at that matter. And so there's an order that goes on appointing this overseer with receivership-type powers. And then that order is subsequently expanded. And after the order of expanding the receivership, and you have to understand, these things have to be, the Domestic Relations Court has to have the ability to act immediately when assets are being dispersed or threatened. One of the allegations is he's traveling to Belize. You know, we don't know what he's doing, but money's missing out of the corporate account, and he's going to Belize, you know, which is a jurisdiction outside the court's jurisdiction to track the money and to find it out. There was an immediate need for action. So the court granted the expanded powers of the receivership. There was plenty of evidence in the court's own view of his failure to comply with things. He wasn't allowing documents to be produced. He wasn't allowing, there were motions for sanctions and other things. There was this federal lawsuit that everybody had notice of. You know, so there's a lot of concern. There was an immediate need. He requested a hearing. The court had already set a hearing to follow up on the temporary orders. It was set for November 8th or 9th. I don't remember the exact date. Okay, and the court actually held an evidentiary hearing on that date, but nobody showed up from their side because it was their position. We filed a notice of appeal, and therefore the court, I guess, didn't have jurisdiction to proceed. I mean, the court was following their request for an evidentiary hearing. It was already scheduled. They filed a notice of appeal that essentially prevented the evidentiary hearing from going forward. And then there was a second evidentiary hearing at which Mr. Smith did appear, did present evidence, and the court still found the receivership to be appropriate. No objection to proceeding based on a lack of jurisdiction at that hearing, but of course now they're saying, and you know, I think the law is correct, that to the extent that that evidentiary hearing related to matters that were on appeal, you know, it couldn't have effect. But we tried to give them an evidentiary hearing. The court tried to give them an evidentiary hearing, and they prevented it by filing this notice of appeal. They didn't actually prevent the evidentiary hearing, but they prevented its being effective, I guess is what I'm saying. Which raises a question whether or not the error may be harmless, because in fact, when the evidence was presented, you know, it was clear that the receivership was not only warranted, but was very essential. Based on the arguments that we've made here, I'm going to rely on my brief for a lot of the remaining arguments, but what I'm trying to essentially say is the court had the jurisdiction under Rule 75I to enter an immediate order based on the affidavit and had the authority to appoint a receiver. There's nothing in the statute itself that says that evidentiary hearing is required, and I cited a number of cases that say an evidentiary hearing is not explicitly required by the statute as far as the receivership statute. So if we default to the Rule 75I, it seems to me that that's very specific, that you can make temporary orders even without notice, and the local rule provides for a method for having an evidentiary hearing which was not followed. So I believe it was waived. Based on the arguments, pardon?
You have 2.5 minutes.
Yeah, I was just going to summarize. Based on the arguments in the brief and the arguments I've made here, I request that the trial court be affirmed. If there is a reversal or remand, I request that the relief be limited to the real estate and not the businesses portion of that order, leaving the receivership in effect for the businesses who did not prosecute their appeal. If you have any other questions, I'd be happy to address them.
Apparently not. Thank you.
Thank you very much. And I sympathize with the voice problems. It seems to be a common thing these days.
Mr. Marco, you have 2 minutes and 45 seconds.
Thank you, Your Honor. I'll try to be brief and handle all of the responses. But the first one I would indicate to you is that there was a statement that NTX and Coastal didn't participate. If you look at the record, they actually filed notice of appeal, and the counsel that did that were fired by the receiver. They were fired by the receiver, who then chose not to appeal a decision that he should have appealed. That is not something that could be held against NTX or Coastal Tool. That's something that could be held against the receiver for failing to prosecute what should have been a clear-cut decision to appeal a case in the best interests of those companies. Your record will reflect a notice of appeal, and then that counsel was fired pursuant to an order that we requested was stayed, and the request was denied. He said there's no statutory provision for an overseer, and then he cites Rule 75I. Actually, the court appointed a receiver under 2735. It's in the very order that we appealed. The authority that was granted was referenced in 2735. It was not a 75I. That's a stretch. That's an attempt to give you confusion on it. There is no confusion. The Supreme Court of Ohio, in analyzing the statute for a receiver, indicates that there must be an evidentiary hearing because a receiver is a draconian remedy that takes away people's rights, for which there must be not preponderance of the evidence, like in every other domestic relations issue, but clear and convincing. To say this was a 75I so far stretches the truth. So far stretches. It's clearly a 2735 appointment of a receiver. The prior appointment of an overseer was the court's acknowledgement and acceptance of an agreement of counsel. The agreement of counsel that was never objected to by either party. They make reference to portions of the record that aren't before you. They make reference to a hearing on a receivership. Why did the court hold a hearing on a receivership on December 21st, when no new motion asked for it? 7 days notice of the hearing in the Christmas holiday season. At a point in time when Mr. Smith was unrepresented by counsel, because frankly he was mad that I couldn't stop this receivership from happening. An attempt to represent himself. I know I'm near the end, Your Honor, I apologize.
You are right, you're at the end.
I would ask you to take all of that into consideration. This, to me, is a clear-cut case. We ask for as quick a ruling as this court can issue. Thank you, Your Honors.
Thank you. Thank you both